All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
You just step through the door. We have some record materials that we're missing, so I'll do a very long introduction this morning. Good morning, everybody. Welcome to the Appeals Court. It's Friday, September 15th. Your panel today is me, Justice Massing. To my right is Justice Henry. To my left is Justice Grant. And there's Justice Grant's record material. So speaking of record material, we have, as probably those of you who have been here before know, we have all of your materials on these handy tablets. And so if we're looking not at you, but at our tablets and scrolling like this, no disrespect is intended. We are looking at the record materials. We are not looking at our web browsers or reading about the latest Red Sox news or anything like that. And we are prepared. We have read your material, so there's you can launch right into your arguments. It's 15 minutes per side. There's no rebuttal, and you're free to use all the time, but there's no penalty for stopping early. I think that's all that needs to be said. So I'll call the first case, which is Commonwealth versus, we're debating on how to pronounce it, Jeanvier, 23P21.
Good morning, Your Honors. If it may please the Court, Timothy Ferreter, Assistant District Attorney for Middlesex on behalf of the Commonwealth. This appeal deals with the second part of the test Hobbs laid out for CSLI warrants, which is whether there's probable cause that the suspect was known to use or own a particular cell phone. And while CSLI might be a newer and interesting topic, I think my argument is very simple, and that's that people tend to maintain their cell phone numbers for an extended period of time.
So you just changed horses, so I want to understand, is it the cell phone or is it the cell phone number or is it both?
So there's two different warrants. One is for the CSLI, which comes from the cell phone number, and then the second warrant was for the physical cell phone. And I think the judge found really was focused on the CSLI on the first warrant in his suppression order.
And at the time of either of the warrants, I mean, we know now that the same phone was used for two different numbers, but at the time the warrants were being sought, did we know that?
So at the time of the first warrant, they did not know that. They knew that for the time of the second warrant. So the fact that the number changed on the same phone is not part of the analysis of the first warrant because it's a four corners analysis, and that's not part of the first warrant.
And how did they know that how did they learn that the same number is being used by two phones?
Because the first warrant requested subscriber information for both numbers, and I think that was part of the return, part of the information we got back from the cell phone provider. So
you asked the cell phone provider to trace one number, and it came back with two?
No, the warrant requested both numbers.
Oh, right, because we knew, but by the time he was arrested, we had both numbers, right?
Correct. And
was there any indication in the record as to why there was a second phone number associated with the phone?
Not with the first warrant, no. With the first warrant, I think me and the defendant both agreed. He writes on a footnote on page 20 is his brief that when we were writing the first warrant, we thought we were dealing with two cell phones. We didn't learn until after we got the return on that first warrant that it was one cell phone with the number changed. So with the four corners analysis on the first warrant, that later information isn't part of the four corners analysis of that first warrant.
Okay, I mean, there's nothing to show in either warrant that the defendant had. I mean, the only information about the defendant's possession of the phones is that he answered he had that one phone number on November 22nd. He had the first number. We know that, and we know he possessed the phone with the second phone number on December 11th when he's arrested.
Correct.
Everything else we have to be going by inferences.
Correct. And just for the first number, they called him on the 22nd, and they also got a subpoena in December that confirmed that phone is registered under his name. So there's those two pieces of information. It wasn't that they just called him, they also confirmed that that was in fact a number registered to him and not someone else's phone number.
Yeah, actually, I was a little confused. When you read through the warrant applications, the first warrant application actually says a search warrant was sent to T-Mobile on December 2nd, and the records received December 3rd were still being analyzed. Is that what's that about?
Right,
It's page 38 of the first warrant application. I'm trying to get a record appendix citation here.
I would need a record appendix because the search warrants aren't 30 pages long.
I've got it. I'll get it in a second here.
Thank you.
So yes, record appendix 82, paragraph 38. A search warrant was sent to T-Mobile on 12/2/20 requesting cell tower information.
I am not sure about the answer to that. I don't know the answer to that question.
That doesn't, whatever that was, isn't a part of this appeal at all.
Correct.
It hasn't been.
I didn't believe there was a warrant then, and
I mean, maybe he's misspeaking.
I didn't. And if there was a warrant on 12/2, it hasn't been challenged.
All right, well,
not part of this
just
appeal.
nailing down the record a little further, the affiant provided no evidence that the defendant owned or used a particular cell phone before November 22nd, 2020, right? You're asking us to infer.
Correct. And I think what this court should do is, there's not a lot of case law on this subject on the second prong of Hobbs, but I would ask the court to look at the staleness analysis in a normal search warrant. And what the SJC said in Gistucci, looking at this analysis, is that information concerning an item that is perishable, readily disposable, or transferable might not establish probable cause even a few days later. But on the other hand, an item that is durable, of enduring use to its holder, and not inherently incriminating might be reasonably found in the same location several weeks later. And I think durable, enduring use to its holder, and not inherently incriminating perfectly describes a cell phone number.
What do we do with the cases, there's some recent cases about guns where the SJC has said if the suspect has reason to believe that the police are on to him, basically, and there might be ballistics evidence on the gun, that would not be reason to hold on to a durable object.
Right, so with the first phone number, we're looking back before the police contacted him. So we're looking before I think the suspect would have any idea that the police wanted to talk to him about this case. The second cell phone number, we know he had it. It was the phone that was on his person that they confirmed, but through text message that appeared on the screen and that he gave at booking was his phone. So I don't think there's any reason to believe that this defendant would have gotten rid of his phone number.
Should we be at all concerned about the fact that this warrant sought basically an 18-day period for CSLI for the defendant's, all of his whereabouts, rather than pinpointing the dates and times of the crimes?
That wasn't an issue in this appeal, so I haven't thought about it exactly, but I think where this was an ongoing crime, there's 12 different assaults. I think learning that location for the whole period would be valuable evidence in this case. Just because of the ongoing, continuous nature of the crime for that whole 18-day period with 12 random assaults, I think that the whole movement would be valuable evidence in this case.
So if we're talking about inferences we can draw about that the use of a cell phone number or a physical cell phone, should we be thinking about this in terms of, the average law-abiding citizen, the average person living out of his car, the average criminal? There might be, if you're, we know that people who, drug dealers churn their phones. So it wouldn't be reasonable to assume necessarily that a drug dealer had the same phone.
No, I agree with that. But in this case where the subpoenas came back, where the phone was registered to his name, there's no indication that he was trying to conceal his number from anyone. This isn't a case where he's using, buying a burner phone with cash and not giving his name. These are phones registered to him. The point about him living out of his car, I think that he's homeless, the value of a cell phone number is in its continuity, because people can't contact you if you keep changing your phone number. So I think people, and we all know, some of us have had the same cell phone number for decades, but there's a value in continuity, and people are going to want to keep their cell phone number for as long as they can. And I think for an average person...
Right, but the problem for you is that he didn't or couldn't keep his cell phone number.
I agree. So I think I was getting there. For an average person, I think you could probably go back as far as the companies keep the CSLI records, which is a year and a half, 2 years, 2.5 years, depending on the company. For a person who's homeless and might not have the means to keep the continuity of their cell phone, you probably can't go back that far, but we're not asking you to go back that far. We're only asking you to go back for the 5645 numbers for 11 days and the 4762 number for a month. So I'm not asking you to go back years, which I think you could do with an average person. I'm only asking you to go back one number 11 days and the other one a month. So I think...
Was there a tower dump done for some of these crimes so that you saw the commonality of a particular phone number?
No, there are no tower dumps done, unless that was the one that they're referring to, but I don't believe there were.
Wouldn't a reasonable inference here be with the second phone number that as soon as he spoke to the police, he spoke to the police the first time because he was either a witness or a suspect, right? And might it be reasonable to infer that he would have changed phone numbers then?
Right, but this is, of course, a probable cause standard. We can't eliminate every single possibility, but I think, under the probable cause standard, a common sense understanding where someone has that phone number on December 12th, I think the reasonable inference is that he's had that phone number for a bit of time, and we're only asking you to go back a month here. So I think there are a lot of possibilities, but we're dealing with the probable cause standard, which doesn't ask for certainty.
So we do know he switched phone numbers for whatever reason, right?
So with the first warrant, we didn't know he switched numbers. We knew he had two numbers in play. We did not know the numbers had changed at the time of the first warrant. By the time of the second warrant, we knew it was the same phone and it had switched numbers. But that was for the physical phone itself.
What dates the switch happened, or one went off and one went on?
I don't have that written down, and I'm not sure if that's in the warrant or not. But for the first warrant, that's not part of the analysis because it's not part of the four corners of the warrant. For the second warrant, it's actually helpful when you're asking for GPS to know that it is actually the same phone, because the GPS is actually tied to the physical phone because it's through your apps, and the fact that your Google account doesn't change if your phone number changes, so it's still tracking your movement on your whatever applications you have that have GPS on them.
So when someone is extracting the GPS data from the phone, do they get other data too, or can they extract only the GPS?
They can extract only GPS. We can do only GPS warrants. In this case, they asked for GPS and content, and below we conceded that there wasn't PC for the content, and we didn't challenge that. We only sought to keep the GPS information.
I'm sorry, you dropped down. So
this warrant requested both content and GPS, but in our filing, in our argument below with the motion, Judge, we conceded that there wasn't PC for content, so we didn't challenge that. We were only challenging for the GPS. And I think Hobbs is the most like case. And Hobbs, the analysis in Hobbs doesn't go deep into this. I had to go into the briefing to kind of figure out what's happening in that case. In that case, Michael Hobbs, who's the defendant's brother, told the police that his brother did not have a place to live and stayed from place to place. He told police that he had not seen his brother in 3 months and that his family's attempts to contact him had been unsuccessful, and that the defendant's phone number was 3938. And then he gave the name of an ex-girlfriend who also confirmed the number, but it doesn't say the last time she contacted him. Here, I think we have better information than they had in Hobbs, where we actually have the number by talking to him on the phone and then confirming it with a subpoena, and then the second number by him giving it a booking and confirming it with a text message to the phone that was in his car. So I think we actually have more PC than they had in Hobbs, and they found there was sufficient in that case.
If police executed the first warrant for subscriber information and CSLI from T-Mobile, and it came back that one of those numbers belonged to a little old lady who lived in Alaska who died in mid-November and gave up the cell phone at that point, would that be evidence of the crime? Would that be discoverable under the search warrant as exculpatory evidence, or is it just?
Well, when we're requesting the search warrant, we don't know what's going to come back. So it could come back that way, and we couldn't unsee that. But I don't know how to answer that.
Do police have to have probable cause that the defendant, that this number is the defendant's phone and was used on this date? Or do they have to have probable cause that the records associated with this phone will be evidence of this crime?
So what the standard is that the suspect was known to own or use a particular cell phone along with the reasonable inferences drawn therefrom. And so I think, it's hard to know, because when they contacted him on the 22nd, they inferred that he had the cell phone for some time. I don't think they knew exactly when the start date for him was and if it belonged to someone else previously. But I think under the probable cause standard, when you contact someone and speak to them on that cell phone number, and then you confirm with the subpoena that he is the actual subscriber, I think there is probable cause that he's owned that number for at least a certain period of time. I mean, the magistrate or the judge who signed this warrant is going to have a cell phone in his pocket with an electronic phone book with numbers that haven't changed for 10 years. So I think anyone with common sense understanding, the search warrant standard, common sense and reasonable inferences are that people.
I just want to interrupt you because I want to get one question in before the bell, which
Sure.
is, at the end of the brief, the defendant argues that the same logic that the judge said required suppression of the November 22nd requires suppression of everything of the second phone number. But there's no, as far as I can tell, there's no cross appeal, there's no cross motion to the SJC. Are we allowed to reach that?
There was my sister did file her own single justice application.
Oh, there
that
is?
was allowed, so it is a cross appeal.
Was it allowed?
It was, yes,
Oh,
and they're consolidated in this case.
Supplemental.
I missed that. Okay, great. That's really helpful. Thank you.
Did you reply to that argument somewhere?
I didn't, because I think my argument in my brief is the same argument I would make, so
Okay.
I didn't think it was
That's what I
necessary.
assumed, but I just would rather
Yeah.
ask.
My argument would have been the same, so I didn't want to waste more paper with the same argument.
Great.
Thank you.
Thank you. If there's
Thank
no
you.
further questions, I'd ask you to reverse the partial allowance and the motion to suppress. Thank you.
I'm so glad you cross appealed. That makes things so much easier.
Good morning. May it please the court. Catherine Sullivan-Ledwidge on behalf of the defendant, CLAUVENS Jeanvier. If I may, I'd like to jump directly to Justice Grant's question about the little old lady in Alaska. And I do believe, and I know, that the standard, the second prong of the Hobbs standard is that the suspect was, quote, known to own or use a particular cell phone. So it's not that we called him on November 22nd, and please let me emphasize that we have no idea where they got that phone number from because they never told us in the affidavit. But we don't know if he got that phone number on November 22nd because the subscriber records that they got, they don't tell us the date he became the subscriber. We have no idea. He could have become the subscriber that morning. And I also want to point out that with regard to the second phone number, 4762, the warrant never states that he is a subscriber of that phone number. Maybe they don't need it because he gave them his phone number at booking. So, okay. But at least with regard to 5649, they somehow call him on a number and he picks up. Is that enough to reasonably infer that before that date he had that number? And the argument about durability, that because someone has a number on one date, we can reasonably infer that they have the number previously, really doesn't work with pay-as-you-go, minutes-based Metro PCS phones when you're dealing with indigent people. Indigent clients often use these pay-as-you-go. They are the least durable phones out there because when their minutes end, their phone number changes. That's just how Metro PCS works. And the second search warrant.
But you don't have to change, you don't have to get a new phone. You can use the same phone.
But in the first.
No, I'm just curious. I mean, it's just a matter of fact, like for
I don't
Metro's-
know. I mean, I assume you
know a little
can
bit about
because you
Metro.
have SIM cards, right? We have SIM cards
Okay.
and we just would change
So that's how you, when you get a Metro PCS, you get a SIM card, is that?
I don't know, but I do know that the number often changes, and the second affidavit even concedes that. And I know that because I work with indigent clients, and I can never reach them. I never know their phone number
So you're
because it
saying
never works.
the standard we should apply is not to the reasonable lawyer or judge, but it's the
Of course.
reasonable homeless or unhoused person living out of a car,
Indigent,
indigent.
who have Obama-type phones, the Metro PCS phones, as they're referred to. They're pay-as-you-go. They are not, they switch, change frequently. So, yes.
You know, on the subscriber information, I had the same question, like why didn't the police include they had some subscriber information, why didn't they give us a date? But the warrant actually seeks those dates. So, I mean, is there an inference that they didn't get those dates from, because they're asking for
You don't
them?
even need a warrant to get, and they submitted an administrative subpoena on December, I think it's.
That maybe the paragraph
December
38.
14th,
Okay.
they obtained records from an administrative subpoena, and you can get billing information, subscriber information, call log information without a warrant. So they already had this information when they're seeking the search warrant in their affidavit. So they already had the information, they had the records. Why didn't they include the date he became the subscriber? Why didn't they include how they got a number out of the blue? It's like a number appears out of the blue. They spoke to his mother. They never asked the mother, what's his phone number? Or does he even have a cell phone? There's not enough information. We're left with so many questions that my argument is that this is supposition, and that's not enough for probable cause.
Well, go ahead.
Well, so I'm wondering whether we should be distinguishing, though, between the phone numbers and the phone, because you can't get data from the phone, right?
Correct, and I do. You can't get to the second search warrant for the phone without the information obtained from the return of the first warrant, and we think there's two phones. So without that.
You'd say if we say the first warrant wasn't proper, then that collapses everything.
And that's what the judge said. You have to excise all that information, and you're left with what you knew as of before, when you applied for the first warrant. So there's insufficient evidence for the second warrant. And that's why I believe when we're talking about the data before November 22nd, the judge was correct, and that needs to be suppressed, and that's where I come in as appellee. I'm appellant with regard to number 4762, which they have no link to him at all until he's arrested on December 11th. We don't have him as a subscriber before that date. That's all we have. So there's no link to him before, so the judge should have suppressed it for all information as of 4762.
So we often think beyond a particular case that's in front of us, and so I'm just thinking about some of us. As far as I'm concerned, the new test for adulthood is whether or not one is paying for one's own cell phone, and that seems to be at age 30 or later, forget 18 or 21. It's my new party question. So what do you keep talking about subscriber. What happens in a situation where you have a parent subscriber and you're really looking at a child's phone number? Does that change the analysis at all?
Well, I think you're really going by the phone number, who's the user. So it's not just the owner of the phone, and that's what they say. A suspect was known to own or use a particular cell phone. So this is why this case is different and why there's not enough information. In all the other cases, Hobbs that I cite, Hobbs, Lavin, Jordan, Lewis, Wilkerson, We know the defendant's cell phone because they tell us how they got that information. It's either billing records. Hobbs, his brother and former girlfriend, tell the police the phone number. Lavin, the suspect's mother, provides the police with his phone number. And they're only dealing with one phone number. You know what I mean? We're dealing with the pay-as-you-go, and they switch. So in all the other cases, they're contrasted from this.
Well, how does it, I mean, in Hobbs, isn't it worse than here? I mean, the brother gives a number that he hasn't used for 3 months.
Correct, but the crime occurs, and they can't figure it out. So if you look at the dates, it's like December, and then the crime occurs sometime in December. February is when they put a public service announcement and they post the surveillance footage, and that's when, so months later, the brother says, hey, I haven't spoken to him in months, but this was his phone number. So he is talking about that previous time period. So it actually did coincide with the time of the crime. I read that carefully because that's what confused me on that one as well. So I think it does support this argument. If there are no further questions, I will rely on my brief.
Seeing none. Thank you both.
Thank you so much.
Really interesting case. It's submitted. And so the second case on for today is 22P881, Commonwealth versus Sabri or Sabri, S-A-B-R-E-E.
Good morning. May it please the Court. Laurie Yashulis for TARIQ Sabri. Your Honors, unlike all of the cases we've seen on the question of whether improper opinion testimony in an OUI case is error, this case actually represents all of the errors we've been talking about since Canty. Every single error that could be committed in an OUI case in admitting improper opinion testimony happened here. First, we have the improper testimony where the officer testified and is permitted to testify over objection on the ultimate issue that the Commonwealth concedes is improper opinion testimony. And
Let's break that down for a minute, because the question was based on your observations to that point, do you form any sort of suspicion?
Correct.
So is that question just by itself improper?
I think the question by itself may not be improper, but then when he starts to get into, based on my training and experience, and that's when the objection is lodged. And so it's kind of a two-part objection, really. And it's our position that the objection is preserved because you've got the first part of that objection starting right when he says, based off my training and experience, there's an objection lodged, it's overruled, and he continues to answer he was operating under the influence of alcohol. The objection kind of continues on for the next couple of pages. There's a sidebar where counsel is making it very clear she's objecting to this officer testifying as to his opinion on the ultimate issue.
According to the transcript, though, the objection was lodged before the police officer said he was operating under the influence. If instead the police officer had said he was intoxicated, would that have been problematic?
I don't think it would have been problematic, and I don't think it really changes anything. The objection continues on as the officer continues to testify. The trial counsel...
Did the defense attorney move to strike?
There was no motion to strike. There was an objection. It was overruled. But throughout this trial, it's very clear that the trial counsel here was objecting to any opinion on the ultimate issue. It's throughout this entire trial. As we go through it, I think there's an objection on transcript page 108. There's several objections on the ultimate issue. And it's very clear that that's her emphasis throughout this trial. on any time the officer gets close to giving an opinion, whether it's on the field sobriety test, whether it's on sobriety, or whether it's here, training and experience, or under the influence of alcohol. She's very clear to the court what she's
Before the
objecting to.
judge overruled the objection, he said, "I'm sorry, did you object?" And defense counsel said, "I objected, yes." Should we infer from that that it was difficult to hear or maybe simultaneous speech as to what the objection was directed toward?
You could make that inference from the judge's question. However, he brings them up at sidebar and clarifies the objection. The conversation continues and he's clarifying it. And it's clarified at sidebar that the objection is to the officer's opinion on the ultimate issue. So even if there is over-talking, even if there is that, it's clarified later.
So, I mean, assuming it is preserved, I mean, why is this case any worse than Gallagher, where it was preserved and they found it was not prejudicial?
It comes down to the instructions, Your Honor. So in Gallagher and Canty, in all of those cases, there's a specific instruction on opinion testimony. In Canty and Gallagher, there's the same thing that happened here. There's an improper opinion testimony and proper opinion testimony. Those are the two seminal cases where we have both types of opinion testimony. And in those two cases, any prejudice was ameliorated or diminished. In fact, the language used is greatly diminished by the specific and strong instructions regarding opinion testimony. And so we've had that language, we've had that instruction since Canty and Gallagher. So
And what was the strong?
the instruction, if I could read from Gallagher, which outlines it pretty clearly. The instruction told the jury that it was for them and them alone to determine whether the defendant was under the influence of alcohol and that the jury was free to accept or reject any opinion on the issue. And this is in the Gallagher case. And the Gallagher case goes on to say that the instruction was nearly verbatim to that given in Canty. So that instruction is specific to OUI cases. It's not a general instruction on you're free to, you're the deciders of the facts, you're the arbiters of the facts. It is a specific instruction in OUI cases that's been around since Canty, it's been around since Gallagher, and Moreno case emphasizes it because their similar instruction was used. So it separates this case from every other case are the instructions.
So the instruction here is repeated, well, at least the Commonwealth sets it forth on page 20 of its brief. It may be in your brief too. But it specifically says that it's the jury's function to determine the facts of the case, and it says you alone determine what evidence you believe, how important any evidence is that you do believe, and what conclusions to draw. Why is that?
So I would suggest those are general instructions that are given in every single case, right? Your function of the jury. This instruction that we're talking about in OUI cases is specific to opinions in OUI cases. And that's what's the difference, because those general instructions are generally given in every single case. And I would argue that it probably given in Canty and Gallagher. I don't know the instructions that were given in those cases, but the specific instruction that those cases are talking to, and in the Moreno case, and in the Dow case, and in the Marquis case, which are both in my addendum, talk about the specific instruction in an OUI case when opinion testimony is offered, whether it's improper opinion testimony or just opinion testimony and sobriety. It's really specific to an OUI case.
Do you know if there are any cases since Gallagher that talk about tactical reasons why defense counsel might not want an instruction that undermines the expert opinion if some, say, for example, some of the field sobriety tests the defendant passed?
So those recent, to answer your question, those recent cases, I think Commonwealth v. Waite is one of them, and there were a couple of other cases that talk about that. Here, I don't think there could be a tactical reason not to request it, given counsel's repeatedly objection to the testimony on the ultimate issue. And she objects to the field sobriety test opinion testimony coming in. She objects to the sobriety testimony, opinion testimony coming in. She objects to all of this. So I think we can make a very fair and reasonable inference that there was no tactical reason not to object. She is objecting. She's strongly objecting. The other thing that's interesting here, so Commonwealth concedes we have improper testimony coming in, and there's no good instruction on that. In fact, there's no instruction on opinion testimony. If you look at the entire instruction, there are no opinion testimony instructions at all in this case.
A juncture of the trial where that could have been addressed was when counsel objected to the closing argument, and the judge said, "What do you want me to say?" And counsel asked for kind of a general, "Don't believe police officers more than you believe other people" instruction, and got exactly what counsel requested.
Well, there was a two-part objection there. If we look at that objection on page 149, actually what she's really objecting to, she says her first part of her objection is, during the closing there was improper opinion evidence in regards to the credibility of police officer. He said, as an experienced police officer, he has an advantage in special training, all of those things. So I object to that characterization of the officer, but then I also want a limited instruction. So, right, they try to fashion on the fly a limiting instruction, and what they get is an instruction on police officer witness testimony. What they don't get is a specific instruction on,
Right, but
training experience.
that's what she asked for.
I think they went back and forth and, how are we going to word this? And that's what they came up with. They did not have, I acknowledge this, and they do not have the benefit of the new supplemental instruction and the jury instructions that was revised in March that talks about, if I could, for your honors, read the label of that supplemental instruction. It's number 3. And I want to contrast it to supplemental instruction number 1. This new instruction is entitled, "If the Commonwealth portrays a police officer as an expert." Okay, so that's new. That's a new instruction.
Where does that word portrays come from? Is it from case law, or is it just in the?
It's in the model jury instructions to be used in district court. So it's just a new model jury instruction. They were revised in March of 2023. And it says, if the Commonwealth portrays a police officer as an expert, this is how you're supposed to instruct. And it says, a police officer's opinion about a driver's, in brackets, sobriety, like that testified in this case, is not an expert opinion based on scientific, technical, or other specialized knowledge, but rather testimony based on the officer's experience, which you may accept or reject. Now, trial counsel didn't have the benefit of this supplemental instruction, but what's interesting about this supplemental instruction, as opposed to the one prior, the supplemental instruction number 1, that one's entitled, if there is an opinion evidence about the defendant's sobriety, and it says you can give that optionally. These are model and jury instructions, and I get that, but when we're talking about fashioning a limiting instruction or some sort of instruction here, this counsel didn't have this guidance, nor did the judge.
What does it mean to portray someone as an expert? What if the motorist who was following the defendant, civilian motorist, said, I could tell he was intoxicated because I'm a bartender and I see drunk people all the time. And the prosecutor got up in closing and said, didn't use the word expert, just said, this guy knows what he's talking about. He sees drunk people all the time, and he said the guy was drunk.
Well, I think that's a little bit different, and I'll tell you why. Because the officer, in a case when an officer testifies, he goes through all his credentials, right? I've got this specific training, I've done these many OUIs. The prosecutor takes him down the road of his credentials, professional credentials. In the case of the bartender, that may not occur, but if that were to occur, if the prosecutor took that bartender down the steps, how long have you been a bartender? Have you received any training on OUI? Then yeah, we're in the same spot as an officer. And that police officer witness testimony instruction is not going to help. But we need one where we have someone that's portrayed as an expert testifying this way.
So the Commonwealth is saying, though, because the defense counsel got a curative instruction on the closing argument, then the defendant acquiesced in that, then that's, any error is not preserved. So what do you say to that?
Oh, I don't agree with that. I think the error is preserved because she talks about the training. I mean, if you look at the actual objection, she says why she's objection. They don't have this benefit of this new instruction at the time. And we're all talking about training and experience. She lodges this objection originally in her first objection on the improper testimony. She lodges it again in closing argument. They're just not really up to speed on how to fashion this type of instruction. But she is objecting. It is preserved. I think what's also important here and what separates this one from Canty and Gallagher is the closing argument. You know, you can't get around the fact that the prosecutor's telling this jury, hey, I want you to take note of the police officer's opinion testimony, and you might know, or you might think you know what a person looks like when they're driving while intoxicated or when they're drunk, but listen to this guy here. He has an advantage, and that advantage is a specialized training. So we don't have those types of closing arguments in Canty, in Gallagher, Moreno, in Marquis, in Dow. We don't have those closing arguments. as I said when I started, this is convergence of every single type of error you can see in an opinion testimony in an OUI case. You've got improper opinion testimony, you've got proper opinion testimony, couched as expert testimony based on training and experience. You have an improper closing argument. You have an objection, might not be the most artful objection, but she talks to the court why she's objection. The limited instruction is not enough. You have no instruction on opinion testimony at all, none, zero. In fact, when the judge gives the field sobriety test instruction, which is supplement 2, he actually leaves out the line that says, you may accept or reject a police officer's testimony, in brackets opinion, or in parentheses opinion, about a person's performance on field sobriety tests. There was no opinion on the field sobriety test, but he actually takes the time to omit that sentence. But he puts no sentence in there about an officer testifying as to someone's sobriety, which is supplemental instruction number 1, which we have in Gallagher, which we have in Canty, which we have in Moreno, we have in Dow, we have in Marquis. We don't have it here. This case boils down to an unfair trial. I mean, there are errors all over this trial, and this case should be reversed.
So I mean, just to note, though, I mean, there also the evidence here is of drunk driving is pretty bad. Open bottle of vodka that had been drunk at 11 in the morning. Terrible driving and crashing into a monument.
But there is other evidence to refute it. We're talking about an island that's in the middle of a driveway that is hard to navigate. He's texting and driving. It's not a huge crash. He goes up on the island with raised curb and hits a yield sign.
He says he's texting and driving.
And he's charged with it.
Yeah.
And,
But he's found not responsible.
He's found not responsible, but he is charged with it. So there's an inference that the officer believes he was texting and driving. Why would you charge him if you didn't believe it? So you've got the texting and driving that explains the driving and explains the accident. But then you have the field sobriety test where he's asked to take off his glasses and do a bunch of balancing tests. I mean, yes, there is alcohol. He said he drank that day, and there's no dispute there. But whether he was operating under the influence is the question, and I don't think on those facts they're overwhelming.
Well, even if he started at midnight, 40% of a handle of vodka is like 16 drinks.
I don't know the answer to that. I don't know how much a handle of vodka is, but, we don't know when he started. We don't know if he works nights. We don't know if he works in the day, and that's the point. We put the Commonwealth to the test.
Well, I mean, he said he drank it that day, so I don't know the best case scenario for him is midnight, right? I mean, is there?
I suppose you could say that, but the point is, this was not this like huge accident. If he's had 16 drinks, he's able to recite the alphabet, he's able to spell. Yes, he sings it. He's able to spell all his medications, he's taking out his license, he's putting on his mask, he's getting out of the car without any trouble, he's answering all the questions appropriately. So even with, I would suggest that 16 drinks, you might not be able to do all that. So the evidence of OUI is not overwhelming in this case, especially where he has to take his glasses off. That's really,
Do we know why he had to do that?
The officers asked him to take his glasses off, and he did.
Okay.
Thank you.
Thank you.
No further question. I rest on my brief. Thank you.
Good morning. May it please the Court. Julianne Campbell on behalf of the Commonwealth. If I could first begin with the Commonwealth's concession. Certainly it was improper for that officer to comment on the ultimate conclusion that was before the jury. However, I raised the argument in my brief that this is not properly preserved. I respectfully disagree with my sister's characterization of the record that trial counsel for the defendant pushed this specific issue. In fact, the record reveals that the objection was in fact lodged after the question was asked. The officer had just started to answer. It appears that was not heard because the court then clarified at the conclusion of the question, "I'm sorry, did you object?" And again, trial counsel lodges a general objection. There is no specification as to what this is for, and given that ambiguity, I'd suggest that case law requires this court to consider this as an unpreserved error. That being said, I go through my brief and in my argument as though it were preserved, because I think under Gallagher, which I would suggest is probably the most analogous case to this one, that this was overwhelming evidence, that the jury was instructed that they alone were to determine the defendant's guilt, and frankly, I don't believe my sister cites a single case in which that type of error, that erroneous opinion on the ultimate issue, does prejudice the defendant such that reversal is warranted. I'm not aware of a case, and I'd suggest there certainly isn't one.
I'm going to maybe I'll the same question, which is, so you'd think by now that police officers would get this right? I mean, right? This is, I don't know how many cases I've had with this error in it, and I can tell you how many that I've been on that reversed it. 0. I mean, apparently the message isn't getting across.
I would disagree with that, Your Honor, because with respect to the error, but with respect to the police officer, yes. I'd suggest the police officer answered the question he wanted to answer because the prosecutor knew that this was improper, and that's on the record. And so I'd suggest that the message is getting across because the trial prosecutor here references his own understanding. Now, perhaps there was an error with preparation of this witness, or perhaps this witness again answered the question that he thought he was being asked, but I would suggest that the message is in fact getting across, though I recognize
maybe
it
not
does
me.
occur.
Maybe ADAs know it, but police officers aren't hearing it.
And I would suggest that that needs to be perhaps the witness needs to be better prepared, perhaps a more pointed question, as the ADA later seeks to do, is appropriate. There are ways that I think this can be passed on further, but given what, I disagree with my sister's characterization, I'd suggest this is greatly overwhelming evidence, even more so of the defendant's guilt than was the case in Gallagher. And so even with this erroneous admission, I'd suggest that the defendant, any impact was but very slight. And I'm happy to go over the extensive evidence. I think the record's before the court as to what the evidence of drunk driving actually was.
Attorney Yeshua says the difference between this and Gallagher is that Gallagher had a specific instruction about about assessing testimony about the ultimate question.
Yes, and I would suggest quite simply that was not pressed below. I'd suggest a couple of things. I know that my sister points to a supplemental instruction that has since been issued. I'd note that it's supplemental, and I'd suggest discretionary. There's no indication that this, well, certainly this judge was not required to intuit that in the future this would come down, but I would suggest that that supplemental instruction is a reflection of this court's case law. In Gallagher, in Moreno, in Waite, and since then. And so I think I welcome the instruction, but it simply was not asked for in this case on any level. And with respect to the error in closing argument, counsel has cited no case in opposition to Beaudry, which is what I rely on for the proposition that the defendant in fact acquiesced to the limiting instruction that the judge gave. And I think that limiting instruction, quite frankly, was very powerful. It's in the Commonwealth's brief at page 21, but members of the jury, you heard testimony in this case from both a police officer and a lay witness. I'm instructing you, and I'm going to get the detailed instructions in the case, but I'm going to instruct you that when considering the testimony, you are to put no weight on the evidence of the testimony presented by a police officer simply by virtue of that person's role as a police officer. Then you would have a lay witness. And I would suggest that the comparison there is to a lay witness. So to the extent that there is any concern that this officer's testimony should have been held in a higher regard, which would have been improper, that's cured by the judge's instruction.
So to circle back, though, to Judge Massing's question, if we keep saying the same thing and then we keep seeing these cases, then it seems like we need to do something differently. Like, I don't know, have a Conti instruction for police officers before they testify that they need to, and that we need to assume they're told this, and then if they're not, so then the choices are they either were told it and they deliberately disregarded it, or they weren't told it, which means the prosecutor's not doing what the prosecutor. Either way, why do we continue to allow the conviction?
Your Honor, I'm respectfully focused on this case, and I hear Your Honor's question, but I'd also point out that this court is going to see the challenges. This court is not going to see the instances in which this is not a raised issue on appeal, because that's the claimed error below. So this court is naturally not going to see cases in which this error is not claimed, because it's an appropriately...
Wouldn't it have been so much easier? I mean, the defendant filed motions in limine about the opinions on the field sobriety tests for the ADA in 10 seconds to say to the police officer, when I ask you your opinion, do not say you have an opinion he was operating under the influence. You can only opine that he was intoxicated.
I'm not disagreeing with that, Your Honor. All I can say here is that the Commonwealth, the prosecutor, took pains to not ask this officer that question. I acknowledge that perhaps there could have been better...
I mean, she could have asked, or he, I don't know which one, could have asked a tighter question.
Certainly, Your Honor, and I recognize that, but this record suggests a couple of things. First, there is no indication the witness was not properly instructed. Candidly, witnesses, there are often instructions, do not refer to this person as a victim, and unfortunately, this person is often referred to as a victim. I'm not excusing it. I'm saying on this record, I don't think this court can infer that the witness was not properly instructed. I agree witnesses should be.
If they were properly instructed, then what are we supposed to make of that? That they just...
Your Honor, there's no indication on this record. I'm asking this court to decide this case. I hear the court's concern. This is not the case to send that message.
Did the prosecutor have an obligation to move to strike the witness's answer when he said operating under the influence?
It's no more than the defense attorney had a responsibility to lodge her specific objection, who represented the defendant at that time. And that was not done here. It's not clear to me that this was even necessarily heard by the court in light of how the transcript reads. But if anyone had the responsibility to preserve the record here, it was defense counsel's requirement to preserve this issue for appeal, which I suggest was not done. And even if it was done, under the case law, this is simply not prejudicial error where the case was this overwhelming. And the jury was instructed that they are the sole fact finders.
Well, so she argues in response to that that was just a general instruction, and if you look at her brief on page 25, there's a much more specific under the influence of alcohol instruction that wasn't given here. So what's your response to that?
My response is that there is no case law that sua sponte requires a judge to give that instruction that you're referring to, and that the jury is presumed to follow the instructions as a whole that they are given by the trial judge. And I'd suggest that that is what happened here, and that it is sufficient to cure the error.
So stepping back, and, we've been given the message that, the mental health of the bar is not great, and the higher we keep setting standards and saying people didn't meet them, we're only increasing pressure on the bar. So it is sort of, what more could this attorney have done? They filed the motions in limine, they objected right in the middle of the improper answer, they had repeated instructions, the judge and the prosecutor knew that the officer shouldn't have made the statements they made. Like, I just, what more do we expect of defense counsel?
I expect counsel to voice a specific objection as case law requires to preserve the issue on appeal.
What words should they have said?
Your Honor, first off, I point out that the objection is to the question and the first three words of the response. The objection is lodged prior to, and I think this is...
How do we know that? Because, a good defense attorney knows what's coming, right? And so the point of objecting is to try to stop the train wreck before it happens.
And, Your Honor, I would suggest that when given the opportunity to clarify what the objection was, counsel, I'm not inventing that. That's what case law requires. And I cannot speak to defense counsel's obligations more than that as a prosecutor. The record stands as it stands. It is a cold record. The objection as the record here is that it was in response to the question and the first three answers. Counsel was given an opportunity to clarify what the objection was to, and that's not clear here. Nonetheless, even if preserved, which I don't even think I address a substantial risk argument in this portion of my brief, because I give the defendant the benefit of preferential error here, and it's still under the case law, this under these facts, did not prejudice the defendant. Perhaps if this was an OUI trial in which the defendant had not admitted to consuming a quarter of a handle of vodka 90 minutes before, if a defendant had not crashed his vehicle, if a defendant had not been slurring his words and simply was offered a alphabet test and then went MNOP or simply fell off the fog line, perhaps that could be closer.
So why
That's
did the
not the case
officer
here.
tell him to remove his glasses? Do we know why he did that?
The record does not know. I do not know. I cannot answer the court's question as to that.
Okay.
The docket shows that the defendant filed several motions in limine, including one about field sobriety tests. Did you include any of those in your supplemental record appendix so we could see whether or not this issue was raised, the issue about the ultimate issue on intoxication versus operating under the influence was raised before trial, and what would have been in the judge's mind when he heard the objection?
So my question, no, I did not include that in my supplemental record appendix. I would suggest that we certainly can provide that to the court if the court would like it, but I'm not sure to what portion, to how that would make an impact, because again, with respect.
Well, if he didn't file a motion
Sure.
about Canty,
Yep.
wouldn't you then be able to argue now he didn't file a motion in limine on this issue?
With respect to which of the three issues raised?
I don't know. I don't know what motions in limine
but-
he filed.
But my position is that I've given in my analysis, and I think throughout the brief, I give the defendant the benefit of the doubt and give a prejudicial review standard. So I only raised that issue with respect to the objection for the court's clarification. But again, with respect to the first, just to go piecemeal through the argument, with respect to the first issue, even giving him the deferential standard of review, I'd suggest this was not prejudicial error because any impact would have been but slight and would not have made a difference. With respect to the second issue raised, the defendant never asked for the instruction that he claims is sua sponte required, and I would suggest that both Moreno and this court's decision in Commonwealth v. Waite, which was decided after the Commonwealth filed its brief, but is 102 Mass Appeals Court 578, that says that a judge is not required to sua sponte give that instruction. And with respect to the third issue, defense counsel raises two claims, the first being that the Commonwealth misstated the evidence. I'd suggest counsel's parsing the Commonwealth's words too finely. And with respect to the second part, the Commonwealth bolstering the credibility of the officer, again, this jury was given a emphatic instruction which I would suggest cured that error, and defense counsel, when asked at trial if they had any further requests, declined to modify that, declined to ask for a more specific instruction. So
To be clear, though, do you agree that the prosecutor should not have said, you know, they have an advantage over?
yes, and again, in my brief, I don't dispute that. And so to circle back to the question about the motions in limine, I'm not sure that it would have, I'm happy to provide that to the court if the court would like those motions in limine. I'm not sure that it has any bearing on the outcome of the case.
So, you know, the definition of insanity is doing the same thing over and over again and expecting different results. Is there some, you know, thing like where you tell us, well, we promise we train our ADAs this way, or when you concede, not just you, but when the Commonwealth concedes some issue, you say at the same time, you've now spoken specifically to the trial counsel and told them this was an error and not to do it again?
So I've spoken with trial counsel in this case. I have, to the extent that I am involved in training district court ADAs and passing along messages, I am happy to continue
I
to.
assume you'd like less work, too.
Certainly, certainly. And I would also suggest that I think it's important to recognize, I realize I'm over my time, but the prosecutor here did realize what was crossing the inappropriate line, and I certainly acknowledge that our witnesses should be better prepared and also know the rules. With that, I'll rest on my brief. Thank you.
Thank you both. As always, the two of you are always prepared and give excellent arguments, so thank you. We were given a message to pause a little before calling the next case to allow the software to catch up, but come on up. The next case is going to be Commonwealth versus Caratini, 22P865. Morning.
Shall I keep, okay, so I have the green
you're
light.
good, you're good.
Good morning, Attorney Michelle Mencken on behalf of JONUEL Caratini. May it please the court. I'll focus on the trial court's errors in denying the motions for new trial. The first error I'll characterize as both sort of a mixed error of judgment and error of law, and it concerns the problematic inconsistency between the witness's testimony and prosecution argument about when the drug dealing evidence surfaced in the apartment and the record evidence as to when the drug dealing surfaced in the apartment. So
can I just pause you on this? Because the prosecution's really arguing that because the judge found it wasn't intentional, it's a pretty tough standard of review for you. What do you say to that?
Well,
You say it doesn't matter whether it's intentional? Or?
of course it matters. It does alter the standard of review.
Okay.
And I think that
And do you agree with her then about what the standard of review is on this?
Well, we've included an argument that there is a significant amount of evidence in the record that could support a finding and should support a finding that there was deliberate and intentional pattern of misconduct here. But for purposes of argument today, I think that even under the stricter standard of this all just being careless, reckless, accidental, unintentional, still Caratini is entitled to relief. So I'll take the error separately, and I will assume for the sake of argument today the stricter standard of materiality. However, I will point the court to the argument in the brief about the abundant points in the record that give rise to an inference that this was calculated, coordinated, and intentional.
And I just want to clarify one thing also before you get to that. I want to hear that. There's no claim here of withholding exculpatory evidence or newly discovered evidence, right? This was all evidence that was there somewhere in the record and available to everybody at trial.
That's correct, Your Honor.
Okay.
That's correct. In the second new trial motion, Mr. Caratini included an ineffective assistance of counsel claim, urging that this was not only prosecutorial misconduct and police misconduct in failing to correct an inaccurate picture of the facts, but it was also error by defense counsel for not using the tools at his disposal to challenge the false impression that the jury was left with. So with regard to the first motion for new trial, that was presented by predecessor counsel strictly as prosecutorial misconduct claim, and the claim was that the prosecutor improperly elicited testimony from the law enforcement witnesses and then improperly argued in closing that evidence of drug dealing only surfaced in the apartment where there had been multiple people staying after Mr. Caratini had returned from his trip to Florida, when in fact there was quite a bit of evidence that while Mr. Caratini was away and Mr. Miranda and Mr. Tirado were occupying the apartment and up to no good, undisputed, they trashed the place and committed a series of serious crimes, that there was evidence of drug dealing observed and collected by the police on that date. So but
the judge says ultimately it doesn't matter because the issue was once the defendant was in the apartment, the evidence of drug dealing was there, including seemingly heroin in plain sight sticking out of the one bottle. Why was that wrong?
So it's wrong. That was what I was characterizing as both an error of judgment and of law. So first of all, the judge says, well, prosecutor was only trying to prove Caratini's knowledge of this stuff. So that's wrong
as a matter of law, because knowledge alone is not enough, as we know from cases like Boria, cited in the brief, and Brown, which Boria relies upon, where you have defendants who share an apartment, who are either not present when the contraband is found, or they're present and it's not found on them. And the question is, how do you connect, how do you prove that, you know, even when it seems apparent that they must have had knowledge, how do you prove that they additionally had the intent to exercise dominion and control? I mean, we're talking about Mr. Caratini was convicted of trafficking the heroin, and also factually, I would say that this heroin was not in fact found in plain view. It was found.
So I wanted to ask about that. Is that on Record Appendix 266 or well, for the PDF it's 266, but of the page numbers at the bottom it's 265, because there's some things found in a cabinet, and so the cabinet door is open, but we don't know whether it was open when he went to bed, so to speak. I mean,
Well, so on the date that Mr. Caratini was home and he went to bed, there is another bedroom at the back of the apartment, and there is a closet inside of that bedroom.
Yeah, those are before these
And
pictures.
police go directly to that bedroom because they think that's where Miranda is. And they open the closet door, and there is Tirado hiding in the closet. The Commonwealth characterizes it as hiding, and I would say that's fair. And then the police look at a shelf in this closet where Tirado was hiding inside of a different bedroom from Mr. Caratini, and on the shelf there is the regimen bottle, and poking out of the regimen bottle is the tip of a baggie, which is later found to contain 35, I believe, grams of heroin,
All right, well, when
along
I'm
with a
talking
scale.
about the kitchen,
So everything that was, oh, I'm sorry, yes, in the kitchen,
is that just the
at the
cutting
time.
agent?
I'm sorry?
Is that just the cutting agent?
So yes, the cutting agent, baggies, and the box that the scale that Tirado had in the closet apparently came in. So that's what's there. There's not drugs on the kitchen table.
Okay, so the drugs are in a separate bedroom.
That's right.
Okay.
With Tirado hiding in the closet with the drugs and the scale. He's packaging it, and Caratini is in a separate bedroom sleeping with
Do we
his
have in the
then-girlfriend.
record a photograph either from trial or from the motion to suppress motion for new trial hearings that shows the drugs as they were found in the closet?
I have not, I never saw such a picture.
Okay.
To my knowledge,
Okay.
there isn't one.
Okay.
I could be wrong about that.
And the safe is from Caratini's room.
So the safe is from Caratini's room. That is seized the first time that police go in, and Caratini's in Florida at the time. That's right. So just back to the importance of when this drug evidence was found. So let's say that the drugs were being packaged on the kitchen table, and Caratini was in the living room watching TV at the time. There still would need to be proof that Mr. Caratini had intention to exercise control over those drugs that were in the kitchen. So that would be, and I would say that the evidence is even less strong here, where Caratini was asleep, and this could have been happening without any knowledge by him. And I will add that unlike when he was away, when police came in on this occasion, nothing inculpatory was found in his room. That was only when other people were making use of the apartment. So that the situation, the hypothetical that I just laid out is more like Boria, and there are several cases where you can be present in the apartment, the packaging and the dealing and everything is going on there, but it doesn't necessarily mean that you're connected. There has to be a plus factor that points to your control over that stuff.
So how does your claim of police misconduct provide that plus?
Because the argument and questioning by the prosecutor suggested that when police were in the apartment when Caratini was in Florida, no drug dealing evidence had been recovered or observed, and it only came to be when Mr. Caratini came back, so therefore he must have been responsible for it. And in fact, that was a completely unfair inference from the
Did the
actual
July
evidence.
22nd warrant, would it have permitted the police to open those bottles?
So they were in it, potentially, yes, because they are looking for ammunition, and ammunition can be inside of containers. They opened boxes, they opened drawers. But regardless, there were scales. There was a digital scale found on July 22nd. There were baggies found out in the open on July 22nd. There was loose cash strewn across the floor found on July 22nd. There were multiple ledgers, at least one of which was characterized as a drug ledger, and police acknowledged at the hearing on the motion for new trial that those items had been seized and listed in the search warrant return. They had been seized as evidence of drug dealing. So that was known to police, it was known to the prosecutor, but it was not known to the jury. The jury never learned that. So there is a scenario here where all of the criminal misconduct is being carried out by Tirado and Miranda while Caratini is away. And
What about the possibility that the defense counsel didn't want to bring that out because it would play into the prosecution's Demoulas theory, that this is a business just like Demoulas supermarkets, and he's still running it even when he's in Florida?
Well, I don't know how it would make the situation any worse. He's already got the fact that there's this stuff in the safe. I mean, there was some stuff there that could be, I'm not arguing that the evidence was insufficient. There was evidence from which the jury could infer that the Commonwealth's theory was correct. But it was not terribly overwhelming evidence. There were serious gaps in their proof. And what we're arguing is that it was completely unfair and unconstitutional for the prosecution to try to surmount those gaps with a misleading picture of the evidence. Like I said, there was...
So, but you're saying with even an unintentionally misleading presentation?
Yes, that's correct, because the prosecution has a duty to correct a misleading impression of the facts. And, you could try to parse, there was an argument advanced by the Commonwealth at some point in the briefing that suggested, well, when the prosecutor argued in closing that when the police were there, they didn't see any evidence of drug dealing, the prosecutor was actually referring to not the July 22nd search, but the later occasion when Officer Yerian came to take the report of the stolen safe. Now, first of all, as we argue in our brief, that was actually not supported by facts. The testimony or representations that the prosecution made about whether Officer Yerian made those observations was not supported by any facts on the record. Second of all, the case law is it doesn't matter if it wasn't straight up perjury. If it's clear that this is a misleading or an incomplete picture of what actually happened, the prosecution still has a duty to correct. And I'll point the court to a case that is cited at some point in our brief, Collins, 386 Mass 1, where an incentivized witness is asked, multiple times, were you given any promises in exchange for your testimony? So technically the answer was no, because in fact this witness plea deal had not been conditioned upon his testimony. However, he had a very favorable plea deal on the table. And the SJC said, by withholding that information, the jury was misled as to this witness's bias. And it was on the prosecutor.
I'm sorry, we'll read the case. I want to get something before the time's up, which is the post-arrest silence issue.
Oh.
Could you address the judge's rationale that the Commonwealth opened the door a little to the post-arrest silence argument.
Or the defense counsel.
Right, that's what I meant. Yeah.
Open the door a little. So the error, I mean, the error, you have to analyze whether the prosecutor improperly used the post-arrest silence and here the pre-arrest silence in an inappropriate way. And I would argue that first of all, the defense counsel did not open the door that way, that the questions that were asked by the prosecutor were completely improper. Didn't you volunteer the combination to the safe, and didn't you volunteer that other people had access to the safe? It's illogical. It doesn't make sense that someone who knew that there were drug proceeds in the safe would call the police and proactively report. Look,
Well, I suspect, I mean, it's either genius or illogical, but, right, because you're like trying to say, oh, well, I didn't know, that's why I reported it.
well, so in order for it to really be okay for the prosecutor to have questioned him about his pre-arrest silence, it had to be, it had to be sort of an inescapable conclusion that any innocent person would have said something at that point. And I would just say that that's completely illogical. And to answer your question, Justice Massing, it's unconstitutional regardless of the defense counsel sort of skirting around the edge. He did not, and even if he had, I think the case that we cite would suggest that it's still inappropriate by the prosecution.
Any more questions? All right, thank you. We'll of course, look carefully at your comprehensive brief before to decide the case. So.
Good morning. May it please the Court, Marina Moriarty on behalf of the Commonwealth. Your Honors, the motion judge, who is also the trial judge, did not abuse her discretion in denying either motion for new trial. With respect to the first motion for new trial, she did not abuse her discretion in concluding that any unintentionally incorrect, as she put it, testimony did not require a new trial where there was overwhelming evidence of the defendant's constructive possession of the drugs found in the apartment. Now, the two pieces of incorrect testimony that were possibly put before the jury was that the inositol bottle that was found on the counter in plain view during the second search warrant of the apartment is potentially shown in those pictures of the execution of the July 22nd search warrant. So to Justice Grant your question, there's no pictures that were taken during the July 23rd, 24th search of the apartment. So the pictures that you have in your that are in the motion for trial that are in the Commonwealth's brief, those are all from the execution of the search warrant on July 22nd, when the police were going into that apartment as a result of shots fired on the first floor and a blood trail leading up to the second floor. They go into the kitchen.
But in general, though, isn't there? I mean, if you're, if you look at the evidence, there is cash, there's cutting agent, there's baggies. They're all present there at the beginning, right?
There is some cash. There's a box of plastic bags on the counter. There's no plastic baggies that are out, and the inositol bottle is on the second shelf in the back, towards the back, with the label not showing.
Right, but the part I'm missing here is that, and I commend the officers of the Commonwealth, but generally they're pretty good at making their own luck and finding evidence. And here, they didn't, this was their job, and we hear all the time about their training and experience and how we should really defer to that. And with their training and experience wanting to find evidence, they didn't see this, and yet somehow this guy, who could be guilty, could be innocent, I have no idea, but this guy, who there's no evidence of his training and experience, he doesn't see it, and he goes to prison and they don't. Because they don't see it. So how do you hold those two together?
I think Your Honor is required to defer to Judge Kazanjian's findings and the testimony that she heard at the first motion for new trial, where the officers testified that they were going into that apartment and that their attention was drawn to another shelf, to the first shelf, where it looked like there was where they believed they had found a handgun. It turned out to be a replica handgun. So there's pictures. The police weren't trying to hide anything. The police were taking pictures of that shelf. But in that moment, they were searching for guns and ammunition relating to the shooting. And so I think Judge Kazanjian's findings that she credited that they didn't see the inositol bottle is entitled to significant deference. They were looking at a gun, what they believed was a gun on a shelf. And the same thing for the regimen bottle. The regimen bottle is clearly depicted in the picture. So the police aren't trying to hide anything. But it's a...
Which is that?
I'm sorry, I don't have it's in the Commonwealth brief. It's a regimen bottle. It's on the floor. It's a small white bottle. The police just believed it was a supplement bottle. Again, they took a picture of it. They didn't look in it. The incriminating nature of that bottle wasn't apparent or clear until 2 days later when there was a plastic baggie sticking out of it. So again, this was, I think you have to consider the scene as it was in the middle of the night after reports of shots fired, blood on the ground, multiple shell casings on the threshold.
But
So
I mean, there's a difference though between what the police were focused in on at the moment, as opposed to several years later at trial, trying to depict that as not having anything to do with the other people.
Well, Your Honor, I think it's undisputed that the inositol bottle between the first search of the apartment and the second search of the apartment was moved. It went from the back of the cabinet to the countertop. The regimen bottle went from the floor in a bedroom to opened with a cap out with a plastic baggie inside a closet with Mr. Triato. Defense counsel didn't notice the discrepancies didn't notice a potential inositol bottle, didn't notice a regimen bottle. Trial counsel testified at the motion for new trial. She didn't recognize this potential issue. No one noticed that these bottles were potentially the same until appellate counsel years later. So I don't think that there's any sort of grand conspiracy here to hide the fact that there was an inositol bottle in the counter.
So
in the
you
cabinet.
started out by saying there were two pieces of evidence that you were gentle and said might be wrong, but it sounds like we're wrong that were told to the jury. So I just want to be really clear we know what you think were the two wrong pieces of evidence.
I don't think that they were wrong pieces of evidence, Your Honor. I think that the argument was that the evidence of drug dealing came about when the defendant returned to the apartment. That is true. The inositol bottle was closed, was in the second shelf of the cabinet. The inositol bottle was out on the counter, along with plastic baggies that were out on the counter, with one plastic baggie on the kitchen table, I'm sorry.
But
it was a digital scale. And so that regimen...
Those are the two things?
No, so it's the inositol bottle and it's the regimen bottle. The regimen bottle was completely innocuous during the first search warrant. It was a supplement bottle that was in the open on the floor. It doesn't matter what kind of...
It's closed on the 22nd, right?
Correct.
And then on the 24th, it's open with heroin sticking out, but it's in a different bedroom from where the defendant is.
Correct.
And were the baggies, did they have the corners cut off?
There was no testimony about the baggies with the corners cut off in the kitchen. So that's the incorrect testimony. Anything that was incorrect suggested that anything the police saw that was relevant to drugs was seized on the night of the 22nd. So should the police have seized the inositol bottle? Probably. But they simply didn't see it. And so their testimony at the time was not intentionally incorrect. On reflection, on inspection of these photographs, was there an inositol bottle in the kitchen cabinet? Yes. But again, this was unintentional.
So her argument, though, is there was nothing inculpatory found on the July 24th search in the defendant's bedroom, and so you need something to indicate the knowledge and ability to exercise control. So what's that?
So you can put together the results of the two search warrants. Granted, the defendant wasn't home during the first search warrant, but that July 22nd search warrant, there was guns, ammunition, a sight was all recovered from his bedroom. the safe that was seized from his bedroom had a gun that matched the caliber of ammunition that was found from his bedroom. The safe had almost $5,000 in cash wrapped in bundles. That was recovered.
Dates that where he wasn't there.
True. That was brought out at trial, Your Honor. It goes to the Commonwealth theory that someone was working for the defendant while he was away. The
So was there evidence about there was the instructions for how to open the safe were in plain view?
That was in the defendant's there was some testimony about that in the defendant's case.
He testified, but there's no picture or.
There was no evidence of that was elicited from the police. It appeared the jury heard this community safe theory, and the jury rejected the community safe theory for whatever reason. It was simply not believable to the jury that the defendant would have reported the safe stolen and not told potentially the jury could have concluded it was illogical for the defendant to have reported the safe stolen if it was and not told the police the nature of the community safe. There was no evidence it was a community safe. It had the defendant's tax returns, paperwork in it, the gun that matched the caliber ammunition that was found in his bedroom. So the ammunition, so this was a defendant's apartment. There's no disputing this was a defendant's apartment. He testified that he exercised dominion and control over its contents and occupants. He told people that they could stay. He testified that he told people that they had to leave. He was present when the heroin was recovered. I already told you what was recovered from his bedroom, the guns, the ammunition, what was recovered from the safe that was recovered from his bedroom. The evidence was that there was active packaging at the time when the police entered the apartment. The inositol bottle was out. Plastic baggies were out. A digital scale box was in the trash in the kitchen, which matched the digital scale that was found in the closet with Mr. Triato. The scene, when viewed together, suggested ongoing, active drug trafficking when the defendant was in the apartment. So I don't think that this court can conclude that Judge Kazanjian, who was a trial judge, abused her discretion in concluding that there was unintentionally incorrect testimony that was presented to the jury, and her analysis of the case is logically and legally sound with respect to whether there was a substantial risk of a miscarriage of justice. If the court would like, I can go into the second motion for a new trial, which focuses more on
that point, though, if you were to withdraw this from the Commonwealth's case, this evidence, I mean, it does seem the Commonwealth thought this was essential to bring out that this stuff was present and hadn't been present on July 22nd.
Well, there's no dispute that there was nothing sticking out of the regimen bottle when the police saw it on July 22nd. There was no testimony so I don't think that that's fair to say that that was incorrect testimony with respect to that regimen bottle. The inositol bottle, maybe. But again, you still have the plastic baggies, the scale, the actual drugs, the defendant's presence in the apartment, all of that. I agree. The Commonwealth's prosecutor spent 3 pages of her 17-page closing argument on that particular issue. She knew she had to prove intent to distribute, knowledge and intent. But the 14 other pages were spent on the multiple inconsistencies between the defendant's statements and his own girlfriend's statements related to the safe. They were spent on disputing the defense theory that Miranda had something to do with the gun in the safe.
So is there a line in between? I'm just trying to understand the case. I don't have a position. But should this be a lesser included offense since the prosecution had to prove that intent to distribute? Like if we were to conclude that it really was essential to that, sometimes we give the Commonwealth the option of taking the conviction on a lesser included or going back.
I don't think that this would... Simple possession, yes, is a lesser included of trafficking. But again, I don't think that the issue is the inositol bottle being in the cabinet, facing away from the officers versus on the counter tips the scale in favor of intent to distribute versus personal use. There was expert testimony on the amount of drugs that were found, the money that was found. There was expert drug testimony related to this amount being more consistent with distribution than personal use. And if there's no further questions, happy to rest in the brief.
No, thank you. Thank you both for helping us find our way through this complicated case. The case is submitted, and the panel is going to take a 15-minute break. I apologize to you who are sitting here waiting for your turn that you have to wait another 15 minutes, but on the other hand, I think you'll appreciate a more rested panel. Thank you. We're back on the record with 22P1236, Department of Children and Families versus Mother. Remind the parties that this case is impounded, so we don't refer to people by names. We refer to them by who they are, mother, child, etc. And we'll hear from counsel for the mother.
Thank you. Good morning, and may it please the court. I'm Sherry Krasner here on behalf of Mother. In life and in the courtroom, whataboutism and finger-pointing rarely are successful ways to persuade. In this case, however, I do need to lay some such groundwork in support of the argument that the judge did abuse her discretion when she found that DCF's efforts with respect to Mother were reasonable. First, the judge here found that DCF didn't use reasonable efforts with respect to Father because the worker failed to consistently meet with Father and failed to provide the child with regular visitation with Father, even when Father was incarcerated. And while the child having a relationship with his father certainly is a good thing, this child had never lived with his father, Father was never seeking custody, and the father only intermittently participated in the proceedings. Second, and much more importantly, there were so many outside professionals involved in this case who offered concrete suggestions about how to help this child and this mother heal and reunify, and DCF ignored everything that they said. First, the case was filed at the end of 2017. A court investigator was appointed, as happens in all cases, in early 2018. That investigator did an extensive report, and she made a specific recommendation. It's in Record Appendix Volume 2 at page 127 about the services for Mother and the action plan that had been developed. The action plan was complete boilerplate. It talked about Mother having proper supervision for children, even though this case only involved a child. It talked about Mother adhering to a visitation schedule with her child, even though no visitation was being offered to Mother at that time. So the investigator said, you need to go back, you need to develop an action plan that is designed for this family. No evidence that the department ever did that. In fact, no action plans were ever introduced into evidence at this trial, suggesting that DCF didn't want the court to know exactly what they were asking this mother to do. Later in 2018, an evaluator at Children's Charter in Waltham interviewed the child, and she made a recommendation. She strongly recommended a parenting evaluation so that Mother could understand the child's history. And that's at the Record Appendix, again, Volume 2 at page 131. Absolutely no evidence that the department who had called for this investigation through Children's Charter ever followed up to have Mother evaluated to see what skills Mother needed to be able to heal this child's trauma. Beginning of 2019, there was a foster care review for the child, for the family. And again, foster care reviews, there are department representatives, but there also are outside people that sit on the foster care review panel. That panel, in early 2019, recommended joint treatment for mother and child. No evidence at all in the record that that ever occurred. And did I say that's at Volume 2 at page 204. And then also there was a CASA that was appointed in this case, a court-appointed special advocate for the child, and he met with the child periodically throughout the case, filed reports with the court, and his report, the most salient parts of his report would be in Volume 2, again at pages 157, 175, and 179. And he said, this child is confused. This child, he knows that his mother is sometimes around, sometimes she is not around. He talks, sometimes he wants a relationship with his mother, sometimes he's really angry at his mother. And the CASA specifically recommended that DCF, you need to address this. This is a confused young boy, and he needs to understand that it's mother's disease in large part, the insidious disease of addiction that is causing her to sometimes be around and sometimes not be around. So the CASA recommends that this occurs. It never happens. So again, not to be finger pointing, not to put it all on the department, but the department had so many opportunities in this case to put in place services that could have helped this mother and this child to reunify, and they never did it. It is true, we know from adoption of Alona, that a judge has to be guided by the best interests of the child even when DCF doesn't fulfill its obligations. However, we also know from Care and Protection of Walt, a case decided 6 or 7 years after Ilona, that a judge always has the authority to order DCF to fulfill its duty to take steps that would make it possible for a child to return home.
So, pardon me, somehow I've managed to have 4 DCF cases this month, so pardon me if I'm confusing the cases, but I don't think I am. This is the case where the mother actually evaded DCF between 2019 and 2021 because she didn't want to give any information about where she was?
The mother had outstanding warrants and was afraid of incarceration.
It's kind of hard to give services to her when she's avoiding them, right?
The case came in at the end of 2017. That's when the petition was filed. And mother her unavailability happened for a brief period between November of 2019 and May of 2020. And then she was having supervised phone contact with the child during that time, so her specific location may not have been known to the department, but she was having that contact at that time, and it was supervised, so there was someone listening on the phone, a department representative for many of those calls, and so there was a way to communicate with mother at that time. And there was all the time, the recommendation by Children's Charter, that happened in 2018. Mother was available in 2018. Nothing was ever put in place. There was testimony to it. Mother had an email address that the department had. So there were, I'm not, again, I don't want to make this finger pointing and putting it all on the department because that's not what it's about, but there were ways that the department could have and should have worked with mother to establish a relationship to provide her.
Can I ask you, the caption of your first argument is mother's request for additional time to demonstrate her ability to care was not unreasonable. Was there actually a request for an additional time, or is that more rhetorical, saying that it was too early?
At trial, mother testified. She says, "I'm not ready to take the child back. I'm in a program." She didn't. Again, I will admit she didn't disclose the location of her program, but she said she was in a program. There was no reason to believe she wasn't in a program, and she said, "I know I can't take him back today. I know that, but don't terminate my rights because I'm here, I'm addressing my issues, and I will be ready." So it's from that we're making the request. We're not saying she wasn't unfit at the time of trial, but we're saying that she was, that the entry of the judgment terminating her rights was premature.
In the child's brief, it characterizes mother as having short periods of stability followed by long periods of instability and a sort of a cycle.
Yeah.
And so why wouldn't it be reasonable for the judge to conclude that this is just a never-ending cycle?
Because I don't think that properly characterizes what mother did. First of all, again, the petition was filed at the end of 2017. Mother was sober for most of 2018. She had a brief relapse, a short relapse at the end of 2018, but then she was back in treatment in early 2019 and continued with treatment, we know, at least until May of 2020. And again, the evidentiary proof for that is in Volume 2 at page 203, and the judge's findings 114 through 144. So again, her period, it is part of addiction, that cycle of relapse and periods of sobriety. But there were shorter periods of relapse and longer periods of sobriety. So it's for that reason that we suggest that the termination was premature. If, however, the court does conclude that the entry of the termination judgment was appropriate, we still would be asking for a remand on the issue of post-adoption visitation. Again, too, the criteria for that, what the judge is first supposed to look at is the best interest of the child. And in this case, what the judge did is she said, well, there's not a strong bond, and therefore it would not be in the child's best interest to have any post-adoption visitation with his mother. But we know from adoption of RICO that bonding is not the only consideration in determining whether it would be in a child's best interest to continue to have contact with a parent post-termination and post-adoption.
Why couldn't the judge, as in adoption of Alona, just rely on the pre-adoptive parents and the pre-adoptive mother's testimony that the family was open and willing to encourage a future relationship between the child and the bio mom?
Alona sets out two questions. The first question is it in the best interest of the child to have continuing contact? And if the judge then determines it is, then she gets to the second question, does she need to frame an order, or can she leave it to the discretion of the pre-adoptive family? And what the judge in this case did, she didn't even get to question 2 because she said it's not in the best interest. So she didn't even have to consider whether or not what the pre-adoptive family was going to do. And the reason the judge said it wasn't in the best interest was because there wasn't a significant bond between mother and child. And what I'm arguing is that, and what RICO stands for, is that you don't only look at the bond to determine whether it would be in the child's best interest. And other things you can look at, and particularly in this case, I mean, this is a child had been abandoned by a lot of other family members. I mean, the woman who was his guardian when the case first came in, she just, completely took off. Child didn't know his father. He was off. There were other family members who hadn't been around for this child. Then there was that whole issue of visitation and phone calls being foisted on the child. A 9, 10, 11-year-old child was the one who was supposed to be the decision maker about whether or not to have contact with his mother. And he wasn't in...
Well, what weight should the judge give his input, or what weight should the judge give to his view at 13 that he wants to be adopted by the pre-adoptive family and he doesn't want to visit with the mother? Children's preferences should always be considered, but they're never determinative, and that you also look at the age of the child. But I'm also talking about they would come to him, do you want to have a visit with your mother? But yet he never really understood about his mother's illness, the addiction illness, and that it wasn't his mother rejecting him, it was her, as a result of her illness, that she was rejecting him. So that kind of work with the child to help him understand that certainly would have been in his best interest, and it might have resulted in a different decision by him as to whether or not he wanted to have contact with his mother. I see that I just have a matter of seconds before my time is up, so unless the panel...
One quick question.
Of course.
In your brief, you take issue a couple of times with the judge you say rolling the permanency plan hearing into the best interest trial. What exactly is the problem with that?
Well, if the judge was going to determine that there needed to be services, that DCF needed to be put in place, then
So you're saying
that would have forestalled the reason to have the trial right then. The trial could have been continued, DCF could have been ordered to put certain services in place prior to having a trial to determine whether or not to terminate parental rights.
so basically by looking at permanency already, she sort of jumped the gun.
Exactly.
Yeah, okay.
Exactly.
Thanks.
Thank you very much. I'll rest on my brief.
May it please the Court, Jeremy Bayless for the Department of Children and Families. This is a mother who for 2 years, up to and through the start of trial, was actively evading the department in an effort to conceal her location from DCF. She was...
So you would take issue with Mother's Counsel who said it was only November to May in 1 year?
I think it depends on your definition of evading the department.
Okay.
Mother's refusing to provide her address or where she's living, and not in a small area. It was, she might be in Saugus, she might be in New Hampshire, is substantial. Her participation in some
But what about the
supervised...
time frame? Can we just nail that down? Is it the months that Judge Massing just stated, or is it a different time period?
I think the time period, as I would consider it evading the department, was November 19 to November 21. The fact that she had some email contact in between is not, in the department's position, enough to break that chain, because it was only contact involving those supervised calls with the child. To participate with the department to satisfy Mario in the case law that is apparent needs to work with service providers. There needs to be more. Specifically in this case, there needs to be a location. If mother is to be referred to specific services rather than the more general therapy, AA type services that she complains about, the department needs to know where she is. It doesn't do any good to refer to a parent to a service in Springfield if she's out on the Cape, and it can't identify.
Was there any discussion, did the department know why she was evading service? Did they understand that she had these warrants?
It's not clear, apart from the fact that mother testified in the court found that she was evading contact with the department, and to a certain extent, fault sort of is not the question. If mother is hiding...
Well, I'm just wondering if, because, DCF has seen this movie before, presumably, and so could actually say to the mother, if you're evading us because you have outstanding warrants, then XYZ, you can get a public defender, we could try to address the warrants.
So I don't believe the record reflects, and unfortunately if it does, I don't recall if there's evidence of those conversations, but mother did have an attorney through this period that was appointed to represent her, who very easily could have addressed those same concerns. The fact that mother had options that she could have pursued to alleviate those doesn't absolve her from the fact that she absented herself from the process, and she did so right up into the start of trial. And what happened during trial is sort of important to how the judge ultimately came out in the case. Mother is gone. She's not engaging with the department. Trial starts. She shows up, and when she testifies, she says, oh no, I know it's been a while since I've engaged, but I've started these services. She doesn't identify where they are. She provides no documentation that would allow the court or the department to verify that what she's saying is true, and the court finds her testimony not credible.
What about the argument that that the department should have explained to the child, the disease of addiction, which I'll grant you many adults have difficulty understanding, but did they even give it an effort?
Certainly. So I guess there's two responses. The first is it certainly would have been better had that happened, were there evidence that happened. But for that to impact the termination decree, the case law is very clear that needs to be raised earlier. Mother's challenges to the provision of services needed to be raised at a time when something could have been done about them. And 4 months into trial is too late.
Well, I'm thinking actually more about post-adoption contact.
Well, several responses to that as well. The first is there is post-adoption contact. The court didn't deny it. It's just not as much as the mother wanted. Secondly, the evidence as of trial was that the pre-adoptive parents were willing to contemplate a future relationship between mother and child. So if mother or if the child were able to get a better handle on it as he ages, it's obviously easier to understand that. Your Honor is not wrong that it can be hard for adults, but as he gets older, it'll be easier for him to process that information when he has it. That could change, and the relationship could develop there. Furthermore, if something does change, they can go back to the juvenile court to revisit the visitation order were that to become appropriate. None of those support this court speculating that there was an error at the time of trial and making a decision based on the information that was true at the time of trial.
Can a parent whose rights have been terminated really go back and challenge and seek a visitation?
The child would be able to go back.
Child.
And as your honors are obviously aware, visitation is for the benefit of the child. It is not to benefit the parents. So if it turns out that this child does in fact need more contact with the parent who, as of trial and for quite a while before trial, he was refusing all contact at all, if that
Right,
changes.
So then let's go back to counsel's argument is we don't let children decide whether there's visitation. We let the adults decide that, and she's saying that got upended for some reason in this case. What's your response to that?
Twofold. First is yet another argument that should have been raised at the time it became an issue rather than arguing with the benefit of hindsight afterwards. Secondly, the evidence is relatively clear that the department was attempting to get the child to agree to visitation. It's not clear how vigorous those were, but we know from the record, it's in Appendix 1 at 31, the lack of interest in visitation comes up in every court report. So the court was aware, mother's counsel was aware during the proceedings of the case that this is what was happening, that the social worker was asking the child if he wanted visitation. The problem is that this is a mother who has a disease. This is a mother who also, and it's not clear the extent to which her alcoholism was responsible, her substance misuse was responsible for this, was volatile. She was violent. She engaged in violent relationships. She exposed this child to violent relationships. She put this child in an environment where he claims he was sexually assaulted by multiple people. So it's not exactly clear, looking back, without this having been raised and argued with a potential evidentiary hearing at the time, it's not clear that what might have changed his opinion. And that's why Gregory and its progeny demand that these challenges to services be done at a time when the court can act, rather than 4 months into trial as a challenge to a permanency plan. So we can, I guess, then transition sort of into mother's status at the time of trial. Mother, at her testimony, testified she had engaged in services. As I said, she provided no documentation or verification, and she was not credited there. Additionally, mother was found unfit because of her exposure of the child to domestic violence. As of trial, mother had participated in services previously, but she testified that she was still engaged with the wrong sort of men and that she had in fact been the victim of a domestic violence incident during trial. She then refused to elaborate further, saying it was, I believe, none of the court's business or something to that effect. Mother was also unable to provide a safe and stable home environment for the child as she moved from place to place and refused to pin down a location, and as she engaged in her own aggressive and volatile conflicts with people in her life. That was the status of the mother at the time of trial, when the court had to decide whether or not she was going to be able to, at some point, address and correct her parental deficiencies. And the court did not err in light of mother's history of failing to do so, that she was not likely to address those concerns, and that the termination of her parental rights was in the child's best interest. And if there are no further questions, I will rest on my brief.
Thank you. We'll hear from counsel for the child, Attorney Anderson.
Good morning. May it please the court, my name is Scott Anderson. I represent the child in this case. I would like to attempt to answer Judge Henry's question from the prior interaction. Mother says herself at the transcript, Appendix 743, I spent 2 crazy years trying to avoid the police. So that's one metric for that time period. Secondly, if you were to look at the Record Appendix, Volume 2, at the mother's exhibits, there are about 24. If you look at the dates, there's only one with a date beyond November 2019. That is a letter from a psychiatrist who says that she did call to get prescriptions filled. That's not even evidence she was taking her medication for 2 years. So those are 2 metrics. We can look at the time frame leading up to and through the beginning of trial as to what kind of services mother herself was interested in taking. We have no evidence of any services in New Hampshire, and it's unclear to me what services DCF here in Massachusetts could provide in New Hampshire where mother was electing to go. So beyond that, we have basically a void of 2 years, a 2-year gap in the record, and we have a judge who is asked the question of what record of improvement is before me such that I could give her more time. Well, you have 2 years of nothing. You have 2 years of a letter from a psychiatrist that she got a prescription, and that's it. So I don't see how it's possible for the judge to come to any other conclusion with a 2-year gap like that. And I don't see the case law in Section 1 of Mother's brief suggesting there's any kind of gap in any of those cases that would...
What about mother's argument that rolling the permanency hearing into the trial was problematic?
On the one hand, I can see why it could be problematic. On the other hand, I would say that because mother was simply unavailable for 2 years, she did start to call in for the trial, which was good, but the judge has some discretion on how to treat, the train is moving on the child's childhood, and the child's entitled to a safe home and a sense of security. And if there's a 2-year gap here, for the judge to roll it in seems like a reasonable action to me, and that's what I would say in response. Though I do understand it's problematic. It's not, quite the schedule that's expected.
We were talking about, I was looking at the transcript. So trial begins on Zoom in August of 2021, and mother is participating, but still whereabouts unknown.
She was calling in apparently from New Hampshire, from what's been said during the trial, from August, September, October, and then, well, I believe she keeps zooming in throughout the trial, but yes, she's zooming in.
But in November, she comes back and she becomes a more active participant in services, is that?
Well, it's in my brief where in the record it is, but on October 26, 2021, she was picked up by the police in some kind of mental state. She doesn't remember what happened. She was drunk, she was pregnant, they brought her to Winchester Hospital, and she began accepting services there end of October, beginning of November 2021. But that's the first sign of any services since November of 2019. So during trial, she started doing services, but that's after the trial started. And finally, about the visitation, I would ask you to look at Isola and look at the 2 questions and recognize that the first question is about whether The bond is mentioned twice in 2 sentences. I had it here, I don't have time to read it. But the bond is whether, okay, the best interest of the child is particular to the child. And there is no rubric you can bring in and just say, these are the factors and this is the bond. Whatever factors we're talking about, whether it's language, whether it's ethnicity, whether it's religion, that is particular to the child and the parent. And so all these other factors are the bond. The bond are those factors as well, how the child feels about the parent, how the child feels about the religion, how the child feels about their own identity, and how the mother can help. That's all we care about. Does the mother help and make the child feel good and it's a benefit? And if not, then no. And if the child's saying they don't want to have visits, that's the final answer as far as the child's position is concerned.
Okay. Thank you. Thank all three of you. The case is submitted. We're going to hear one more case in the courtroom. Go ahead. You're have a good weekend. We're going to hear one more case in the courtroom, and then we have one more DCF case on Zoom after that. So if the people for the sixth case are watching, it's probably about 40 minutes. So about 12:30 we'll actually get started. But so calling the last case for the courtroom, fifth case of the day, McNamara versus McNamara, 22P759.
Good morning. Police the court. My name is Michelle Shoemaker, and I'm representing the appellant today, who is the plaintiff in the underlying case. After listening to so many other serious matters before the court this morning, I'm wondering if an issue of child support is, a modification of child support is of the same weight. However, after going through the trial, it appeared that the judge's decision had errors in there. We question whether the judge correctly applied the provisions of Mass 208, Section 38, or Section 28, and the child support guidelines.
To just step back, the father seems to be making an overarching argument that mother really didn't disclose what she should have disclosed, and that was basically disqualifying for her petition, and I wondered what your response was to that.
The omissions on the financial statement that mother submitted to the court were, I would say, inadvertent on her part. She had in the past done occasional online sales of things, but she was not currently doing that. She had a photography part-time hobby business in the fall where she would have a few customers that she would take pictures for Christmas money, is what she testified to. At the time of the trial, it was not the fall, so she did not have that income. Father also references.
Well, let's step back, leave the mother. Let's assume hypothetically that somebody seeking modification and an increase in child support intentionally didn't disclose some income. And the court finds that. Is that the end of the inquiry then, or does the judge still have to look at a change on the other parent's side?
I would think the judge needs to take a look at the entirety and consider the entirety. It was mother's testimony that she didn't think she had to mention this small amounts of income because they weren't current and not currently happening. There were assets that came up that mother had not put on her financial statement. Mother had, prior to the divorce, she had been in an auto accident. On the way to the hospital in the ambulance was involved in an auto accident. So she was compounded injuries. She had a hip replacement. As a result of the hip replacement, she had all sorts of other chronic pain, chronic edema, all sorts of other issues that led to a disability. For reasons I have not yet figured out, but I can only assume, was that she had not had a sufficient work history in her life. She did not get SSDI, but she qualified for supplemental security income. So she was receiving at the time of the divorce supplemental security income. Now that is a needs-based benefit, the parties also have an autistic child who receives supplemental security income. And as a needs-based benefit, when the income into the household goes up, the SSI goes down. And that was happening. The child's child support upon the sale of the marital residence went from, I think it was $240 to $320 a week. Because of that change, there was a diminution in the SSI benefit, and mother had not been able to carry on those hobby crafts that she had done before because of increasing disability, because the medications that she was being prescribed weren't working.
Well, again, I mean, the lack of disclosure, the testimony, the judge also drew negative inferences about the mother's disability. And just more specifically on Justice Henry's question, so you're raising three issues: the imputed income, the calculation of the father's income, and the retroactivity.
Yes.
And I mean, it seems to me, putting aside father's income for a second, the judge's ability to impute income to your client, and maybe the decision not to grant retroactive modification might have been. Could that be? Is it affected by the judge's credibility determinations?
I'm not sure if it's affected by her credibility determinations, but it certainly seemed to me that she bore a dislike for the mother, and that bore in her decision-making. She also was the judge who presided the trial.
But it's not based on it's not based on any factors other than the mother's conduct in the trial.
And I look at the inclusion or exclusion of asset on a financial statement. While it is important to have such a declaration, if you're handling a divorce, because you need to know what assets are. But in terms of a modification of a child support, I'm not sure that was such a necessary thing. If the omission was inadvertent on her part, does it go to her credibility as a whole? I think it's a minor thing, and it should not have affected her testimony and her credibility as to the nature of her disability and her inability to work. The judge just took off and said, well, I'm going to impute a 40-hour work week to you, when there was Social Security, supplemental security income statement in evidence that said you were fully disabled. And she testified that she had just had a meeting with SSI, and they had re-upped the full disability.
So but is the judge bound by that determination by a federal agency? I mean, I get for consistency purposes it's uncomfortable, but I was asking if the judge is bound by it.
I did not find any case on point that says you're bound by that determination. However, it is a practical and pragmatic thing to follow so that benefits aren't messed up by what a court orders. And certainly I think mother also testified.
The judge imputing income to the mother isn't going to affect her Social Security payments.
But in terms of the mother had testified that her benefit would not be affected. She could work and earn up to $600 a month without it affecting the benefit.
Mm-hmm. Right.
$600 a month is certainly not the same as a full 40-hour work week. And she testified, too, that she was physically unable to even do that. And the judge discounted that and slammed her with a full 40-hour work week at minimum wage and imputed
How
that.
can we, who don't have the benefit of seeing the witnesses testify, how can we find that erroneous, that credibility finding?
I think that to make it, I think the judge could have been a little bit more definitive in her findings if that was where she was going, that thinking that there is I do not credit her testimony for this or for this or for this, and then as a whole, I do not credit her testimony at all. The way it was written, it just sounded to me like, I have a dislike for you, and this is what I'm going to find. And as to bolstering that particular line of thought, not addressing the issue of the mother's request for a retroactive income modification. Now, the judge just automatically stuck a number there and said, okay, there was no addressing the issue of retroactivity. And for that, in the case law, I saw where it needed to be addressed. Whether she said, mother has asked for a retroactive application of the change in child support, and I'm denying it, could have been handled in one sentence, but she didn't even address it at all, and she was required to. And because she was required to and she didn't, then that is a grounds for appeal.
So I'm normally on the iPad, we can search, but if there's a flaw in the document, the searching function doesn't work. In your brief, on page 14, you cite a finding from the judge that says the mother's capable of working 30 hours per week, and I don't see a record cite there. And I tried to just search through the other documents, and it wasn't jumping out at me. So do you know what the record cite is for that?
What page was that?
In your brief, you're on page 14. It's smack in the middle of the page. You quote, the judge found.
That was citing the Ferrum Cappuccino case.
Oh, okay, all right. So here, did the judge just said the ability to work full-time?
Exactly, in this case.
Okay.
And then citing the LL versus Commonwealth, that it was abuse of the judge's discretion to attribute 40-hour week to the plaintiff.
So I think where the parent says, well, I make Christmas money, there's sort of an implication that there's a choice there and that they're just choosing not to do that work at another time. Can the judge conclude that that's not an okay choice?
If the judge was going to conclude that, then the judge should have stated it, and the judge did not. And I think the mother's testimony throughout was very consistent about her inability to do work. And if I go out and I work today, what is my pain level tomorrow? What is my edema level tomorrow, based upon how much energy I'm putting into it here? With the photography, she said she had maybe 5 to 10 customers. That she could space out as she felt she could handle it physically, because there's not a lot of moving around involved in photography. You put your camera on a tripod, you raise or lower the tripod depending upon the angle you're looking for, and for that, she's able to handle a little bit to get some extra Christmas money to buy gifts for the kids.
You address on the father's income. You do some calculations, and the Father's Counsel says that you err by dividing the gross income to date by 9 instead of 10. What's your response to that?
I looked at the statement and brought it back to the earliest portion of the year on the calendar to see, was this a carryover from a December, January, and it did not appear that. It appeared that it was starting from January 1st forward. And so I based it on the number of weeks of the calendar that had elapsed at the time of this.
So you maintain that there were only 9 weeks represented in that?
Yes.
Yeah, okay.
And looking at that, and looking at his overtime, premium overtime, extraordinary overtime, he works for the T, and the T is notorious for, we would rather pay you overtime than hire sufficient other personnel to fill the slots so that everybody just works a regular 40-hour week.
The judge purported to include overtime, right?
She said she included overtime, but when I ran that calculation, I could not match those numbers. I took out, the regular wage, I added just basic overtime, it still didn't match. I ran any number of permutations of the numbers to see if I could get to the number that she arrived at, and I could not do it.
Any idea how the judge arrived at $570 a week for your client? Is that minimum wage times 40 hours?
Minimum wage at $14.75 an hour times 40-hour work week comes to $570. But as for the father's overtime, where he had been habitually working overtime prior to the establishment of the child support order and continue to habitually work overtime post-child support order, then in any modification request, the overtime is includable in its maximum amount. There's been no diminution in his workability. He's gone.
Is it mandatory to include, or is it discretionary with the judge?
It is not a mandatory overtime, but
I mean, it's mandatory for the judge to include overtime
it is,
in the child support guidelines.
by case law, yes. When overtime was worked prior to the order of the support order and continues to be worked after the support order, there's no presumption that the overtime should not be considered in setting the future child support. And that was the Vidensky case cited in Ramos v. Lopez. So, where he had, and the documents submitted into evidence of his W-2s and pay statements bore witness to the fact that he was continuing to do the maximum amount of overtime every week that he could. It's not that it's mandated by the T, but everybody likes having that extra in their pocket. And with that, I will conclude my arguments, unless there are other questions.
Seeing none, thank you.
Thank you, Your
We'll hear
Honors.
from, well, I'm not going to try. I want Attorney Pollack to pronounce it for me. Was that close?
Thank you, Your Honor. Attorney Donna Pollack, if it pleases the court.
Simply Pollack, okay.
Thank you, Your Honor. I understand from what the Justice said that there's a feeling perhaps that we're overreaching with her fraud. I think that what counsel, who was not counsel for the first trial, fails to understand, and that perhaps wasn't considered, is that the justice in the district court also had the benefit of knowing what the testimony was in the original court. The original findings found the mother to be not credible in that hearing as well as her mother to be not credible and her aunt to be not credible in their attempts to defame the father and glorify the mother. Not only did that come up in the first trial, but what this justice had the benefit of was knowing how mother actually got her disability. And that was based on the medical evidence that was presented at that time, which would indicate that mother had received several infections from her drug use, which led to an ongoing cause of health problems. So I think that perhaps in this court she's being presented as much more sympathetic than she appeared in the original trial, where it was shown that my client had to leave his job to come home to be able to care for the kids, and that for several years while she was in and out of rehab, he in fact did that. So the justice in the lower court had the benefit of that. I think that the fraud is a very important part of this case. I think that when she comes in as the plaintiff and says to the court, I would like you to make this change based on what I'm telling you, and then what she's telling you isn't accurate, I think that should very much be considered by the court.
What's your best case for that proposition?
That she's being inaccurate?
That's the end of her case at that point?
I'm not suggesting it's the end of the case. The judge did apply child support guidelines and in fact did apply overtime. I think what might be being missed, and I put in my appendix, was the footnote that was in on my client's financial statement, the father, which showed that under the regular pay, we included 10 hours of overtime. So that is the number that the judge took, and that shows on his pay stubs that we included 10 hours of overtime because he routinely receives that.
So I'm not going to say it was me, but somebody here tried to replicate the math and was having difficulty doing that. So can you, and it seemed like the judge did not start with the number that the father put on his own sheet, which seems problematic.
I do believe that there was a $49 error between what the judge found and what was on his financial statement. I do not believe she included the income or the contribution of household members. That I think it was $38 for the sister. I don't believe she included that, but she included the regular line, which I do believe there was a $49 mistake on. But that, again, did include the overtime. And if you look at that first paycheck stub, so the very first paycheck stub, and that date goes, The pay date is from the 2nd to the 15th, so it's a 2-week paycheck. When you look at the current earnings in year-to-date, you can see that it's all doubled. So it is all doubled. That he got paid on the 1st of January for the 2-week period that preceded that. So the first paycheck, I have no doubt, is a 4-week, the first paycheck that's in evidence is for 4 weeks of pay. You have his current earnings and you have his year-to-date earnings. They're double. You have his current deductions, year-to-date, and it's doubled. So at that point, he's at a 4-week pay period. And when I used those numbers this morning and I took out only the premium overtime that he had earned, the number is correct. $2,118, I believe, is the amount that he earned with 10 hours of overtime included in that. So the judge, in her discretion, included 10 hours of overtime and then didn't include the other overtime, which was discretionary. And while counsel is suggesting that he works tons of hours of overtime, the majority of the overtime you see for that year was the week preceding the trial. We knew we were going to give that paycheck because they had requested it of us, and we did in fact give that paycheck, which showed the week before trial he worked 10 hours of overtime. So I don't think he was trying to hide anything, but the judge in her discretion, which she has, included some of the overtime and not all of the overtime.
So your calculation, the 2118, that's the $49 mistake.
No, I think the judge...
Because the judge found $2,069.80 a week, and
Correct,
you said it's $21.18.
And I believe my number is correct. So I think the judge had a slight error in her calculations. And
do we need to remand for recalculation of the guidelines just for that?
I don't believe that it should be remanded for a $49 error when the... I don't believe that a $49 error is worth remanding it for. I think it's a minor error on a larger check.
We need to remand for express consideration of retroactivity.
When I read Bolter, I don't read it that way. What I believe it says is that it does not have to be expressed, but rather that certain factors have to be considered, and I believe the judge considered those factors. One of them being if it's in the best interest of the children, the lifestyle. I think the judge made it explicit that the children's lifestyle is okay. Mother has bought a new car, mother has bought a new jet ski for them, mother goes on a vacation every month with the children in the summer, additionally took them to one tropical vacation, took them to Orlando. So I don't think there's a question that these children are suffering, that they're being neglected. Mother testified that she was able for Christmas to buy the child a $1,000 laptop. So she lives with her mother, and the court specifically found that she lives with her mother who's paying the bills. Mom testified, I had to increase how much I paid to $125 because my parents' income went up, expenses went up, and then the judge found that she wasn't even really paying that. So she's got her parents paying for the electric and all of the household bills. She testified they pay all the household bills. She only paid rent. So I don't think there's any question that these children are not living a very nice lifestyle. Now, in contrast, when you look at my client's financial statement, I believe his net pay after taxes is about $1,300, and he has a $500 rent. So I don't think it would be in the best interest for the father to have to pay all that back. He's down to about $600 in net pay after he pays the child support and he pays his rent. So I think that the court considered all of that, even though she didn't expressly say it. She certainly talked about the lifestyle that the children were living. And again, just going back to the fraud, I think that the courts need to take offense to the fact that somebody does this to the court. Not only that, but I know that I cited the case about playing hide and seek. We were given the bank records, which were requested months before the day of trial. And then we were given them electronically, and the court had to print them out for us, had to set aside time for the trial for us to get those. So here's a woman who's not even complying with the discovery requests, which we needed to be able to show her income. So that morning, I received these bank records, and even with that short time, I was able to show income that was coming in from an unknown source. She's got deposits coming into her bank account, and her explanations were that she sold certain things on eBay. She also had other accounts she didn't talk about. She had other accounts. She had prepaid accounts. She testified that she hid $25,000 from the federal government so that they wouldn't take away her benefits. She literally testified that she was committing fraud on the federal government, and then says to the court, but listen to me and give me every single penny you can give me. My poor client had to pay all these bills, including coming up to the appeals court, because she wants more money when she's living a better lifestyle than him, lying to the court and asking you to include every single penny he makes, but not all the money she makes. So I do think that we should take that, and I do believe it's offensive to the court. What is happening there?
So is attributing a $570 a week income to the mother, is that based on evidence, or is that just based on, the judge's what justice would be done, feeling of justice?
I would suggest it's based on evidence. We talked about what the mother was doing. She's jet skiing. She's telling the court that she can't stand for a long period of time.
Well, don't you sit down on a jet ski?
You do sit down, but I believe, well, I'm going to suggest it's a powerful motor that you're holding on to travel around a lake. I'm going to suggest that is a strenuous activity.
All right, but what evidence was presented that the mother could work full-time?
I think it was just presented that she was working and she was hiding it, and that she was capable of doing other things. She was capable of snorkeling with the children. She was capable of walking around Disney. I know she said that she, when I cross-examined her on it, because when I began the examination of her and I suggested that perhaps her sisters were the ones her sister was really the one taking care of the kids, she was adamant. She did everything with the kids. She was there, and she was the one parenting and taking care of the kids. And when I turned it around on her to say, so you were able to walk around for the 2 days without any problems, suddenly she said, well, I needed a wheelchair. But she went to the beach, she went snorkeling, and she was able to do all these other things. The judge, I don't think it's too much to assume that there's no testimony about her education or skills, but the judge didn't suggest she could get a skilled job. The judge is suggesting that she just simply get an entry-level position. That could be gotten anywhere, and I know that counsel suggested, common knowledge. Here in the Commonwealth of Massachusetts, we know that there's thousands of jobs out there that people can't fill. Burger King, McDonald's, Market Basket, all types of jobs that can be filled for minimum wage. So if mom can do all of these other activities, the judge is suggesting she can work. Additionally, she's a photographer. She previously put it down on her financial statement that she was doing photography, and now she took it off. But she's got 5 apps on her bank records, which were only reviewed that morning, 5 different apps for photography, to make things with it, ornaments and those types of things, to send it out to clients. We presented her with the app that photographers use to send pictures to their clients, and it's on her bank statements. So she is working. I don't think...
So there's monthly payments for...
Yes, so there were monthly payments, and we went through every one, and I know that I list them in my appellate brief. Every single app that she uses for photography, 5 different ones. But now, she also said she earned money previously through making crafts and T-shirts and things for people, and says she's not doing that now. And then we showed purchases on her bank records that showed she was doing it. So I think that the judge, relying on the testimony she had seen at the first trial, carrying that into the testimony of the second trial, because there are findings that says she wasn't honest in the first trial. I think the judge has the right to do that. The judge did apply child support guidelines, included some of the overtime, not all of the overtime, and I think that's a fair decision.
Do we have the original divorce judgment in the appendix?
I'm not sure if it is in the appendix. I do have it with me today, but the original one, she indicates that the wife testified that the husband's sister and who she relies upon to help with the children is not an appropriate caretaker, that the husband and the sister are drug addicts, and the court finds it's not truthful. She testifies that her aunt and her mother were the ones who really took care of the children, and the court doesn't find that credible and doesn't find their testimony credible either. So that court had the benefit of all of this information. And all of that information was in findings that the court made. So I would suggest to the court that the decision that the judge made was appropriate. There was no indication that it was in the child's best interest that retroactive child support be applied, that they needed it in any way. There was absolutely no testimony that these children went without anything. The mother lives a nicer lifestyle than the father.
What was the child support payment before the modification?
I believe it was $370, and it went up to $400. So mother did receive an increase based on the child support guidelines in those 10 hours.
Well, I think we understand the argument, so.
Thank you. If there are no further questions, I'd rest at that. Thank you very much.
Seeing none. So that case is submitted, and that is going to be the end of the session. In this courtroom, we're taking one more case on Zoom in a few minutes.
Thank you.
Thank the court officers, thank the clerks, and we'll be in recess. And thank you, counsel.